Hi everyone, I'm Nancy from Dun& Partners Solicitor and Company, and today I will be analyzing a critical employment law issue based on Phoebe's case, her request for flexible working arrangement upon her return from maternity leave. This presentation will also look at the law governing flexible working hours, the respective rights of employees and employers, and the relief available if one goes to court. I will also examine if any form of discrimination is an issue and assess on the chances of success that Phoebe will stand to make claims. In doing so, my objective is to give a summary of the law and its application to the facts, as well as providing Phoebe usable advice she could proceed with. In a nutshell, Phoebe is a full-time property manager of Home Countries Property Management Limited for 7 years. She requested to reduce her working days from 5 to 3 days per week to care for her son. However, her employer refused, pointing out that all property managers have to be employed and work full-time in order to deliver excellent services. Phoebe's appeal was also unsuccessful, and she is now struggling with what legal rights she has and what form of redress are possible. Let's look at the legal framework that governs flexible working rights. Section 80 of the Employment Rights Act 1996, as amended by the Flexible Working Regulations 2014, provides employees who have worked continuously for at least 26 weeks to have a statutory right to request flexible working arrangement. This could include working fewer hours, having a complex work week, or sharing a job with someone else. Such requests have to be considered by the employer in a reasonable manner, and the employer and employee will have to work out the final decision in a maximum of 3 months. However, the employer can refuse the request if they can justify it. This might include reasons such as how the request could affect the quality of work, performance, customer needs, demand, or the availability of work during the proposed hours. In Phoebe's case, the employer dismissed her demand because property managers are bound to work full-time if they have to offer the required professional services. Yet, their reasoning seems feeble because they neglected to gather data or consider alternative solutions, such as job sharing with a colleague who is available to work 2 days a week. This made one question whether HCPM company truly executed her request according to her statutory recommendations. Second, let's look at how Phoebe could rely on indirect sex discrimination under the Equality Act 2010. This happens when an employer applies a rule or practice that look neutral but unfairly disadvantage certain workers because of a protected characteristic. However, the employer can defend their actions if they can prove that the rules serve a legitimate purpose and is necessary and appropriate for achieving that goal. In Phoebe's case, the employer decided that all property managers should work full-time, a decision that could particularly impact women as they are often the ones responsible for childcare. This policy became a challenge for Phoebe in balancing her childcare responsibility as it does not offer flexible working hours, making it very difficult for her to maintain a positive relationship with her workplace. If the employer intends to counter a claim of discrimination, they must be prepared to demonstrate that their policy is reasonable and justifiable. While it is understandable for a business to aim for high standard of client service, HCPN company has failed to consider proportionate alternatives, such as job sharing or staggered hours, which would better accommodate the needs of employees like Phoebe. This principle is supported by the key case law, British Airways versus Starmer. A refusal of part-time work was ruled discriminatory where reasonable alternatives could have been implemented. Phoebe's situation aligned with Starmer. as her employer's rigid stance and lack of accommodation could amount to indirect discriminations. Hence, Phoebe has two potential claims. One is under Employment Rights Act, specifically related to flexible working regulations, and the other is under Equality Act, concerning indirect sex discriminations. In the flexible working claims, it is up to Phoebe to show that her employer fails to consider her request in a reasonable manner. The employer's blanket refusal, without evaluating alternatives like job sharing, strengthened her case. Relief available for these are quite few, including an order requiring the employer to reconsider her request and compensation not exceeding at-risk pay. As for the discrimination claim, Phoebe would center on the disproportionate disadvantage caused by the policy or practice. Her employer's failure to explore reasonable accommodation undermines their defense. Measures against discrimination are broader and may include monetary remedies for financial losses as well as damage for emotional distress. The latter is quantified according to the vendor bands, with the lower tier ranging from £1,100 to £11,200. Phoebe's success in this case will largely depend on the strength of the employer's justification. While HCP company may argue that full-time work is necessary to maintain quality service, their failure to explore reasonable adjustment, such as job sharing, significantly weaken their position. Tribunals typically view employer unfavorably when they disregard such requests without making reasonable accommodations. Without evidence of effort to accommodate Phoebe, the employer's argument that full-time work is essential for high-quality service may not be convincing. Also, the employer rejects her request, and this does not correspond to the 21st century trend where the work-family interface is becoming more and more hospitable. Cases like Holmes versus Chief Constable of West Yorkshire Police in this case highlights that indirect discriminations must be objectively justified. Phoebe's case also points out the delicate issue of equality of rights between employer and employees. The employer has the right to implement policies that ensure operational efficiency. However, they are also under a legal duty to prevent on-workplace policy have adverse impact on their workers, especially those with protected characteristics. At the same time, employees also have contractual entitlements that are part of their agreed term of employment, including the rights to demand workplace flexibility and protection from discrimination. Employers can often find solutions that meet business needs while addressing workers' demands, especially when a teamwork model is promoted. In this case, job sharing could have been a viable option to achieve both objectives. For this analysis, therefore, my suggestion to Phoebe is that she brings a claim to the employment tribunals for breach of the flexible working regulations and indirect discriminatory. In order to build her case even further, she should participate in a mediation or settlement conference in order to look for a solution outside of tribunal. Furthermore, Phoebe needs a substantial proof, including all correspondence related to the flexible working request, its refusal, and any subsequent appeal. Phoebe's claims are well supported by legal precedent and statutory rights, giving her a strong chance of success. In conclusion, Phoebe's case highlights the importance of adopting a fair and reasonable approach when handling requests for flexible working. While employers may have legitimate business reasons for not wanting to be held accountable for pregnancy-related absence, they must carefully consider how their policy may negatively impact female employees, particularly those with family responsibility. Phoebe has a strong legal grounds to pursue claims under both the Employment Rights Act and the Equality Act. If successful, she could receive compensation and possibly a revised working arrangement. Thank you for your attention, and I'm happy to answer any questions.